Good morning, everyone.
Good morning.
Good morning. Before we begin, any special requests from the state?
No, Your Honor, thank you.
Ms. Greggio, any special requests?
Your Honor, I would just ask for Mr. McInnes. There are medical issues. He's still in the infirmary. He was continued from yesterday. If you wanted to take that matter first, we would just ask that an interim bail be set.
All right, let's call Philip McInnes. This is a first appearance bail hearing. I will appoint the public defender's office to represent him in the interest of justice. What's the state's position regarding his custody status?
Your Honor, we're asking for bail in the amount of $10,000 as well as DAS supervision and testing for controlled substances in this case. I can give the court more details, but if the defense is just asking for interim and we'll submit, then that's what we're asking for.
And Ms. Greggio?
Your Honor, I'll submit on that. We have no information to provide.
All right. Or was that interim bail in the amount of $10,000 by surety or 10%? Conditions shall include supervision by DAS and testing at random. The next court date will be a 72-hour hearing on December 19th. If there are no other cases to call out of order, I will call them in the order they appear in Odyssey. The next case will be two matters continued from yesterday for Victoria Carter. Public defender's already been appointed. Scored a 13 on the risk assessment. What's the position of the state?
Yes, Your Honor, in this case, we are asking for $30,000 total bail. I anticipate filing both these cases as one case. So if the court wants to break it up between 5,000 on the controlled substances case and then 25,000 on the fraud case, I have no objection to that. The defendant has criminal history going back to 2014. It appears controlled substances have been an issue for her for a while. She had a trafficking arrest that I don't show a disposition for in that year. She also had a misdemeanor conviction for possession of drug paraphernalia in 20. Looks like she had a couple years of issues in Carson City and Lyon County. So she had a misdemeanor conviction for possession of drug not for interstate commerce in 21 in Carson, then possession of controlled substance and obtain and use credit card with no disposition in Lyon County. Then she had a possession of drug paraphernalia conviction in Dayton in Lyon County, and then a contempt arrest in Carson City. Then in 2022 had a possession of drug paraphernalia here in Reno Justice Court, had a possession of drug paraphernalia conviction in Carson, had a conviction for possession of drug paraphernalia and violating condition of release in Carson, and then a failure to appear arrest in Lyon. Then in 23, she had a misdemeanor conviction for violating probation in Carson City. And then in 24, she had a misdemeanor conviction for violating probation in Carson City and a misdemeanor possession of drug paraphernalia in Carson City. So concerning here, obviously, with the multiple substances, also the large amount of documentation indicating kind of a fraud lab in the process here. We believe that she's a risk to the community, risk to continue this conduct, and believe that the bail, as well as DAS supervision, testing for controlled substances, and no contacts with the co-defendants would be appropriate. And with that, I'd submit it.
Defense.
Thank you, Your Honor. In this case, Ms. Carter is unable to afford any cash bail. And so we would ask for an OR release with conditions. We were able to speak with Ms. Carter's mother, who does indicate that she does have a phone number, a cell phone number. I know she had a 13 on the NPRA. One of the points was for not having a telephone number. And I will indicate that, or I will point out that according to the NPRA, she did not score a point for failures to appear in the last 24 months. And she does not have a history of violent crimes. I think her criminal history, which is mostly misdemeanor, the felonies sound like they're all drug related, do indicate a potential issue with substances. And so again, Your Honor, I think with respect to that, with respect to her risk to the community, I think her risk of not appearing is low. With respect to risk to the community, I think testing would be appropriate, as well as supervision to minimize that risk. And with that, Your Honor, I will submit. We're asking for OR or significantly reduced bail from the $30,000.
Mr. Reichenberg, the failure to appear arrest that you mentioned, do you have the date for that? In Carson City?
So the last one was in 2022 in Lyon County. Would the court like a more specific date than that? That does fall outside the NPRA score, but I can get the date if the court would like.
No, that's fine. I just wanted to clarify the date. I appreciate the information. The court does find at this time that the state has met its burden to establish by clear and convincing evidence that the defendant poses a risk of non-appearance, a risk to the community, and a risk to engage in further criminal activity as that is contemplated under the bail factors. The court has considered the mitigating statements offered by defense and finds the least restrictive means as a reduced amount of monetary bail and conditions. In the case ending in 895, that is the PCS. Bail will be set at $1,000 by surety or 10%. She shall submit to supervision by DAS or the successor agency and testing. In the case ending in 896, bail will be set in the amount of $5,000 by surety or 10%. Supervision by DAS or the successor agency and testing. And Judy, her next court date will be?
It'll be a 72-hour for December 19th at 9:30 a.m.
Thank you.
$600 cash. Oh, bond. Okay.
This one. The next case is Francisco Ortiz. Public defender's been appointed. This matter was set over from yesterday. Is the state prepared to proceed?
Yes, Your Honor. With Mr. Ortiz, we're asking for $5,000 bail, DAS supervision, and testing. The defendant has a fairly abysmal criminal history as of late. A lot of his history comes from Reno Municipal Court. So he's had 18 cases in 2024 and 2025 in Reno Municipal Court, 16 of which were for possession of drug paraphernalia, 2 trespass cases. Of those cases, in 11 of them, he has failures to appear. He's got a number of them still active. And then, in addition, in that time frame, he has possession of drug paraphernalia conviction here in 24. His history goes back to 2010. Had in 19 a gross misdemeanor conviction for take a vehicle without consent. Same in 17. That was here in the second JD. 12, he has a felony conviction for possession of stolen property, 2 different cases with felony convictions. And then going back further, more drugs, a DUI conviction also in 11. But he's a pretty much constant presence in Reno Municipal Court over the past couple of years, again, with 11 cases he's failed to appear on. So this is a pattern for Mr. Ortiz, and we believe bail is necessary to ensure that he actually deals with this matter. Not to mention, he will just continue this conduct as he's demonstrated with those 18 cases in the last 2 years. Thank you.
Ms. Greggio?
Thank you, Your Honor. In this case, Mr. Ortiz has indicated that he cannot afford any amount of cash bail. However, he is open to a OR release with direct transport into treatment based on the criminal history, the charges, the facts in the probable cause sheet. Pretty obvious that there are some substance abuse issues going on. Again, he's indigent, unable to afford bail, and the types of crimes in his recent criminal history are pretty much in line with what he's being charged this time. So we would ask for an OR release with a direct transport to into inpatient treatment.
The court finds at this time the state has demonstrated by clear and convincing evidence that the defendant poses a significant risk of flight. Scored a 14 on the risk assessment, recent FTA history within the last 24 months. For that reason, the court will impose both conditions and a monetary amount of bail. Bail will be set at $1,000 by surety or 10%. If he posts, he will be subject to supervision by DAS or the successor agency and testing at random. I hear defense requests to authorize direct transport to an appropriate inpatient facility. So in the alternative, so it's either post or I will authorize direct transport. And you'll let me know. I need to fix that language on the order. All right, thank you. The next case is Nicholas Tippery. Public defender's been appointed, scored a 5 on the risk assessment. What's the position of the state?
Yes, Your Honor. In this case, we are asking for $20,000 bail, DAS supervision, no contact with the co-defendants. And we would also ask for testing on this defendant, even though he does not have a pending drug charge as the other two do. His criminal history goes back to 2014. Frankly, this crime I think is indicative of substance issues and the kinds of crimes that people commit to obtain financing for controlled substances. His criminal history goes back to 2014. It says felony conviction for possession of a controlled substance and also conviction of possession of drug paraphernalia. It's a bit unclear to me because it says the final jurisdictional court was Reno Justice Court. So I'm not sure that was actually a felony conviction, but clearly a drug conviction and arrest nonetheless. 2015 had a misdemeanor conviction of trespass in Reno Municipal Court. In 2021, he had a felony arrest for possession of document to commit or personal ID to commit forgery. Obviously concerning given that's what is underlying this case as well. And he had a deferred adjudication in that case. So he's just 4 years ago had a very similar case, had resources and an attempt to intervene and was apparently not successful given his arrest here. He had a failure to appear arrest in 24. I couldn't tell what was underlying that. It was traffic or if it was one of these older cases. And then was also arrested at that time for trespass that was ultimately dismissed. So again, history of similar items, clearly long-standing drug issues, and so we believe that bail and the supervision and no contact with the co-defendants and testing is appropriate. Thank you.
Ms. Greggio?
Thank you, Your Honor. So in this case, Mr. Tippery has indicated that he is unable to afford cash bail. As we've heard, there is no indication of failures to appear. Mr. Tippery has been in Reno his entire life, 38 years. He does stay with his mother in the Monty Ranch off and on. We were able to speak with Mrs. Tippery, and she did indicate that he's welcome to return if he is released. She also did confirm to us that he is employed. He's employed doing deliveries, things like DoorDash and Uber Eats. And so with respect to his risk flight, we don't believe he will be a risk flight. So with respect to that prong, based on the charges and the history as the state indicated, it does seem that this is more of a risk to himself, substance abuse. So some risk to the community based on the charges. But again, we believe that that can be mediated through supervision. So we would ask for an OR release with supervision conditions, testing, checking in. And with that, I'll submit, Your Honor.
And Your Honor, I apologize. I do just want to correct. He does have 2 points for failure to appear, and we did mention failures to appear. So we believe that's an issue here as well. Thank you.
Thank you, Mr. Reichenberg. I reflect that the MPRA does indicate 2 points for failures to appear, so I will take that under consideration. The court will find at this time that the least restrictive means to ensure the defendant's presence is an owner cognizance release with conditions in place. With some reluctance, Mr. Tippery, given your prior failures to appear. However, I am going to give you one opportunity to demonstrate to the court that you can abide by conditions and appear out of custody. If you fail to appear at the court date that we will shortly announce, a warrant may issue for your arrest. The conditions will be supervision by DAS or successor agency and random testing. No contact with the co-defendants in this case. Your next court date will be December 29th at 9 a.m. for an arraignment. The next case will be Quayshawn Sheridan. Public defender has been appointed. The defendant scored a 15 on the risk assessment. What's the position of the state, Mr. Reichenberg?
Yes, Your Honor. So in this case, we are asking for $20,000 bail, DAS supervision, comply with all registration requirements. Recently, in this past year, defendant seems to have developed a pattern of being places he is not welcome. He has 2 citations in Reno Municipal Court earlier this year that are still pending for trespass. He had a fail to register that was no issue on November 26th, and then had another citation for trespass. And now we have not only was he trespassed, but not registered, and frankly was in custody just a couple weeks ago. So should have updated his registration before leaving the jail. I'm not sure why that did not occur or what happened there. But Ben's criminal history goes back to 2004 robbery felony conviction in New Jersey. His registration offense, he has lifetime supervision at a 2018 case down in Las Vegas for attempted sexual assault. Has an arrest in 21 for false statement obstructing with no disposition, and then an arrest for ex-felon and possession for sale as well with no disposition. Had a felony conviction for failed to register in 23, also in 24, had an obstructing in 24. So this is I guess be characterized as a known and ongoing issue for this defendant, similar to the trespass. And the defendant does not seem to get the message and do what he needs to do, and therefore is a risk to the community, as well as a risk to continue that ongoing conduct. And therefore we believe that the bail is appropriate, and supervision if he were to be released. Thank you.
Ms. Greggio?
Thank you, Your Honor. Your Honor, in this case, we were actually unable to speak to Mr. Sheridan this morning. He was unavailable to us. However, he does not want to continue this until tomorrow. So I would ask for interim bail. In the meantime, we were not able to speak with him, interview him, try to get any information. So I I I can only I have no facts on which to submit.
Would you like me to trail it until the end of the calendar?
Mr. Sheridan is indicating no. So, I mean, if Your Honor wants to set bail, again, I will leave it up to Your Honor. I have not had an opportunity to speak to Mr. Sheridan.
And Ms. Greggio, do you have another member from the Public Defender's Office there with you this morning, or are you solo?
She's here, yeah. Again, if Your Honor wanted to trail, I'm fine with that. Mr. Sheridan is indicating he does not want that.
Why don't we trail this case, Mr. Sheridan, so you can talk with the public defender and we'll recall it.
Thank you, Your Honor.
Thank you.
You're just
Sheridan.
You're just gonna come back up in like 5 minutes. Just go talk to that lady.
We'll hear the case today. We'll just trail it till the end. Next is Oscar Valladares Iglesias. Public defender's been appointed in this case. Is the state prepared to proceed at this time?
Yes, Your Honor. We're asking for $10,000 bail, DAS supervision, no contact with the juvenile unless in compliance with HHS or CPS family plans. I believe this would also be bondable only pursuant to the court's administrative order. The defendant, sorry, no weapons also, and that's due to the allegations of violence. The defendant has criminal history going back to 2015. Concerningly, in that year, he had a domestic battery arrest that was ultimately dismissed in Sparks Justice Court, and then he had a conviction for violating a domestic violence TPO and destruction of property here in Reno Justice Court. Then in 2023, he had a number of arrests, including an arrest for resisting and carrying a concealed machete, which was ultimately dismissed. He had a failure to appear arrest, then a misdemeanor conviction for trespass, then a misdemeanor conviction for assault, a felony conviction for graffiti, and then a misdemeanor conviction for obstructing. So again, concerning case, given the allegations here, it does appear that I believe that CPS is involved, and so we believe that based on the criminal history, the allegations here, the failure to appear, I don't know that's reflected on his criminal history because that was back in 23, or as far as the MPRA. But again, believe that bail and the conditions is appropriate. Thank you.
And the request, Mr. Reichenberg, was for 2,000, not 20,000.
Sorry, no, 10,000, 10.
10,000. Thank you. Ms. Greggio?
Thank you, Your Honor. In this case, we're asking to set a bail of no more than $500, which is what Mr. Valladares can afford. In this case, his NPRA at a 4, normally it would be a low. Here they stated it's been overridden due to the criminal history. I'm not quite sure why, because the points he gets on the NPRA does adequately represent his criminal history. He does have one prior felony that was a defacing property graffiti charge, and then the other criminal history stated by the state. So again, I don't understand why it was overridden to a medium. In my belief, it should be a low. His reference did verify all of his personal information. He's been in Reno his entire life, 36 years. With respect to the child, Mr. Valladares indicated to me that the child is currently with his significant other who resides in a different residence. He did indicate that CPS is involved, and CPS has indicated that he would be required to complete certain things and to test twice a week. Mr. Valadares does have another child who resides with the mother, so children have two different mothers. And so in this case, you know, he has, I don't see a prior history of failures to appear, at least not in the last 24 months. You know, his ties are to Reno. I don't see him as a flight risk. With respect to safety of the community, again, that child has been removed, and he will be required to do certain things through CPS before he can be reunited with the child. So I think the conditions that CPS will impose on him will be sufficient. So again, if Your Honor does find either a flight risk or a risk to the community, I believe the $500 that he can afford to pay would be sufficient to ensure his future appearances and to protect the community, along with again, I don't know if Your Honor wants to order conditions in addition to whatever CPS will be requiring him to do. But certainly, you know, CPS's involvement should be sufficient to protect the child in question in this case.
The court finds at this time that the state has met its burden by clear and convincing evidence to establish that the defendant poses a risk of safety to the community and a risk of safety to the named victim in this case. This is an alleged crime of violence. The court has considered his employment status, length of residence in the community, as well as the other factors, and will reduce the amount of bail. Bail will be set in the amount of $2,000 by surety only pursuant to the court's administrative order, as this is a Category B felony. If he posts, he's not to possess a firearm or weapon, as this is an alleged crime of violence. And he will be restricted to contact with the minor child, subject to the provisions of the Human Services Agency. His next court date will be a 72-hour hearing on December 19th. Next case is Ryan Bush.
No.
And Mr. Bush, you indicated that you wish to hire your own attorney.
Yeah. Later
Have
on.
you, All right, have you retained an attorney for today's hearing?
Yes.
And no, she's asking if you've hired an attorney.
Oh, no, I have not hired an attorney for today, no.
All right, would you like to screen for the public defender's office to determine if you're eligible?
Sure. I don't know.
She's gonna ask you some questions, yeah.
Okay.
I need
She's gonna see if you
a
call
printout.
for the public defender.
Okay.
All right, Mr. Bush, I'm going to ask you a few questions to determine your eligibility. Do you receive any government aid,
No,
Medicaid, food
No.
stamps?
no.
What is your weekly household income?
It's a commission job, so like on the low end, probably like $500.
Thank you. And the total number of persons that reside in your household?
Just me.
And do you receive any income while you are at the Washoe County Detention Facility?
No,
Do you own a home?
no.
Do you own a car?
Yes,
Do you own it outright or are you making payments?
I own it outright.
All right. And do you have any stocks, bonds, or investment accounts?
No.
Based upon the defendant's statements, the court will find that the defendant is presumptively eligible for representation in this case and appoint the Washoe County Public Defender. Let's proceed with the hearing. And is the state prepared to proceed further, Mr. Reichenberg?
Yes, Your Honor. In this case, we're asking for $25,000 bondable only bail given the category B. DAS supervision, no contact with Ms. Donaldson or the college court address. We'd also ask for DAS supervision and testing for controlled substances given their fairly central role in this case. The defendant scores an 8. He has criminal history going back to 2018 where he had a DUI conviction in Reno Municipal Court. In 2019, he had 2 subsequent probation violations in that case. Then he had a DUI in 21. That conviction was here in Reno Justice Court, and then he had an arrest the next year for probation violation. So, while not as substantial as we sometimes see with 2 DUI convictions, I think what's concerning here is that the defendant has a track record of having a case and then having issues following through and making sure that he completes what he needs to do and stay out of trouble. So that I think warrants some consideration for risk to the community as well as risk to continue offending. I'm unsure. I just show the with the probable cause sheet, the home invasion, the destruction of property. It's a pretty substantial amount of controlled substances. I'm not sure if that's going to come down as some sort of separate issue, but obviously very concerning given that level of controlled substances also in this volatile situation. So we'd also ask for no weapons given the understand he forced his way in without a weapon, but given the domestic component here, we believe that no weapons is appropriate as well. Thank you.
Mr. Reichenberg, the request for no contact order, is that pursuant to NRS 178?
Yes, Your Honor. Thank you.
Ms. Greggio?
Thank you, Judge. In this case, Mr. Bush has indicated that he is unable to pay any amount of monetary bail, so we would ask for an OR release with conditions. We were able to verify his cell phone, his residence, and his employment through his reference. So that would bring his NPRA score down to a 4, which is a low. We were able to speak to Dennis Bush. He is Mr. Bush's father. Mr. Bush did confirm that Ryan Bush, my client here, has been working at the same place for the last 7 months. As he indicated, it's a sales row, DeBella Windows. Mr. Bush was also able to indicate that Mr. Bush lives at his apartment on Mary Street and that he has a working cell phone number. So again, from that reference, being able to verify that information, it does bring the NPRA score down significantly. The criminal history is not extensive. There are 2 prior DUI misdemeanors. However, the criminal history and the facts in this case does indicate a potential substance abuse issue. Again, we believe he is not a risk of flight. He has lived in Reno his entire life. His entire family is here in Reno. And again, he does, have that address, that working phone number. So we would ask that in terms of condition to mitigate the risk, testing would certainly seem to be appropriate. We don't oppose to the no contact or to the no weapons clause. But again, we are asking for an OR in this case with those conditions.
The court finds at this time that the state has met its burden by clearing convincing evidence to establish that the defendant poses a risk of safety to the community and a significant risk to the named victim in this case. Therefore, the court finds that a monetary amount of bail and conditions are appropriate. In consideration of defense's argument regarding the reduced NPRA score, the court will assess bail in the amount of $10,000 by surety only. He's to have no contact with Evan Donaldson and the address at 317 College Court. That is effective immediately, both pursuant to court order and pursuant to NRS 178.4845. No contact means stay 100 feet from the named victim. Do not contact, including by person, phone, text, email, electronic means, or through social media, either directly or through a third-party agent. A violation of the no contact could result in additional criminal charges. If he posts, he will be subject to supervision by DAS or the successor agency. He's not to possess a firearm or weapon, as this is an alleged crime of violence. And he shall submit to testing at random. His next court date will be a 72-hour hearing on December 19th. Next is Steven Rodriguez. Public defender's been appointed. Risk assessment was a 4. Let me start, Mr. Reichenberg. What's the position of the state?
Yes, Your Honor. So, in this case, we are asking for bail in the amount of $50,000, bondable only. The fentanyl charge is a category B. Most of the other charges are category C, felonies. DAS supervision, testing for alcohol and controlled substances, given the issues reflected here. The defendant, I know from the MPRA, said he had a probation violation. However, I'm not sure if my criminal history was pulling up adequately, but this is the only arrest I show for him on his criminal history. So I'm not sure where that probation violation came from. It looks like there's some traffic issues that he had in Reno Municipal Court, but I'm not sure that would be anything that would cause this probation violation. So I'm not sure if I'm missing something or what the status is there. However, this is a veritable pharmacy of controlled substances we have here. I think, as I read the PC sheet, indicated the defendant indicated he was on his way to a rave, and I think he was on his. It appears he was on his way to a rave with enough for everyone there at the rave. Obviously, there's a multitude of substances here, very dangerous substances. Obviously, the trafficking levels of fentanyl is extremely concerning. The ketamine, the LSD, it's frankly a very concerning case of how just the multitude of substances and the reference in the probable cause sheet to all the baggies and vials evidencing the sales, and the fact that again, sitting in the car with the open bottle of tequila, clearly had been drinking, and one of the passengers was doing whippets right as in full view of law enforcement. So this was clearly fairly brazen, and again, concerning for the rest of the community, given just the breadth and amount of substances. Again, didn't mention cocaine yet, but a pretty good amount of cocaine as well. And so this is an individual who, while no criminal history, again, just the amount and volume of substances gives the state great pause for the likely ramifications and of the sales, as well as just the time it would take to build that sort of broad inventory. So with that, I would submit it, Your Honor.
Thank you. Ms. Greggio?
Thank you, Judge. In this case, Mr. Rodriguez has indicated that he can afford no more than $500 in cash bail. We do not believe he is a flight risk. We were able to verify some of his personal information, his employment, and his phone number. So that should bring that NPRA score down to a 2, which is very, very low. Again, he has no criminal history. We were able to speak to his mother, Catherine Rodriguez. She did confirm that Mr. Rodriguez is part owner of the home where they all reside. They have lived there for 6 years. Mr. Rodriguez has lived in Reno his entire life. He's 36. Again, he's a property owner. She did confirm to us that Mr. Rodriguez does have a working cell phone number. She also said that Mr. Rodriguez has always worked and supported himself. However, the company he was working for recently shut down. He's currently doing odd jobs, and Mr. Rodriguez indicated to me that is correct. He occasionally works as a stagehand for shows in Tahoe. His mother indicated that he does have skills in construction. He does general handyman type work. So again, no one knows why that probation violation was listed. This is his first arrest. Again, there's absolutely no indication of flight risk given he doesn't have a criminal history. And so, again, the charges are concerning. So again, Your Honor, if you find that monetary bail is necessary to protect the community, we would ask for an amount that comports with what Mr. Rodriguez can afford. And again, supervision would be appropriate given the seriousness of the charges. So we don't oppose supervision. We only ask that bail is reduced from 50,000 to perhaps 2,000.
The court is certainly troubled regarding the allegations. These are serious offenses, category B, category C felonies. The court has considered the nature of the charges as that pertains to the defendant's risk of non-appearance. He scored a 4, which is low risk. The offense placed into the record that he is a longstanding member of our community. Therefore, the court does find at this time it is appropriate to both set monetary bail and conditions. I will set bail in the amount of $2,000 by surety or 10%. He shall be supervised by DAS or the successor agency and subject to random testing.
And would the 10% option be available on this category B?
My review of the administrative order would be that this does not fall under the administrative order as it does not involve a human victim, firearm, or residential burglary. So
Okay.
it's discretionary.
Thank you.
So by surety or 10%. But make no mistake, Mr. Rodriguez, if you fail to appear at your next court date, a warrant may issue for your arrest. I expect appearance in court and compliance with the conditions as stated. Next court date is a 72-hour hearing on December 19th if he doesn't post.
Sorry.
Yeah. Why don't you just step over the. Yeah, that's fine.
So she can cover next. December 19th, yeah.
Are we ready to call the next case, Ms. Greggio?
Yes, Your Honor.
Next case is Mr. Wallace. The public defender's already been appointed. Is the state prepared to proceed at this time?
Your Honor, with Mr. Wallace, we are asking for additional time to reach out to the victim, Stephen Wallace. So we would ask to continue it one day, understanding it's a couple of issues here today, and then I wasn't sure. I still have one set for an arraignment. Is would that be more appropriately like a bail revocation hearing, or has he not been arraigned on the 25-13-3468?
Both are on calendar. One, hold on. I believe that was a charge of
It's
the
both on,
468 case.
yeah, so it's both on for a revocation as well as an arraignment. He has yet to be arraigned on it, and because of this new charge, they're set it for revocation this morning.
Okay. By so on the violating the no contact order, I am asking for a continuance of one day to reach the victim, and I would submit it as far as going forward on the other case today.
Ms. Greggio, would you like to weigh in?
So if I understand it, it's a violation of a no contact and a separate violation of release condition case.
He's also set for DAS violation 15.
How's that?
Go ahead, Judy.
So, because of his new arrest for violating the contact order, his DUI case was a DAS ad book. So that is what we're hearing today. It is an OR revocation with arraignment because he is yet to be arraigned on the DUI, as well as the new case for violating the TPO.
There's no
Not a TPO, violating the no contact order.
Correct, I apologize. It's a no contact order.
Well, so the state's requested you can one day continuance to comply with Marcy's law. I'm inclined to grant that, Ms. Greggio.
Certainly, Your Honor, they're entitled to ask for that. I have no basis to object to that.
All right, so we'll pass it one day based on the state's request to comply with Marcy's law. I'm sorry. For judicial economy, I think it's appropriate to keep both cases together.
right,
So
well-
both cases will pass until tomorrow.
Agreed, Your Honor.
Thank you, Your Honor.
The next case will be Dylan Stanley. This is a first appearance on a fugitive warrant.
And Your Honor, Mr. Stanley is waiving his appearance.
Looks like it's out of California. He's waived his appearance, so we will see Mr. Stanley back for the 72-hour hearing.
That'll be on December 19th at 8:30.
Next is, and I apologize if I mispronounce this, Sion Kokitolu.
Hello, Your Honor.
Morning, public defender's been appointed. This- An arraignment and a bail hearing, although. Yes, are you in receipt of the criminal complaint Miss Greggio filed August 7th or April 7th? I apologize, of this year.
Yes, Your Honor, we did receive a copy of the criminal complaint. Is your name 100% correct or no?
Yeah.
Mr. Kohitolu indicates that his name is spelled correctly. And he does waive a formal reading.
And Miss Greggio, before you decide what hearing we're setting next, would you like to address the bail hearing, or will he be requesting to set a speedy preliminary hearing in this case?
One moment, Your Honor.
Of
I
course.
mean, and Your Honor, I would note, I was going to today ask for the bail remain on the warrant, but continue the bail hearing. I don't show that. Well, so we have been in contact with the victim in the past. He was not apprised of today's hearing, and so I would ask to continue it to get his input if he wants to provide it, as he's been involved in the past. There's another co-defendant, Mr. Altizer, and I would note it looks like he was set for an MSC on the 31st, I think is his next next date. He's represented by Mr. Minnick, which I'm not sure which office Mr. Minnick is with, but I provide that for defense in case they need to evaluate their representation on the case.
Thank you, Mr. Reichenberg. My apologies for not turning to you first. So I understand your request is for a continuance pursuant to Marcy's law
Yes,
on bail. All
on the
right.
bail hearing, yes.
Ms. Greggio, anything further?
So, Your Honor, based on that, Mr. Minnick does work for our office. It may appear that there may end up being a conflict. So given the request for continuance on the bail hearing, I'll just submit on that. And I did not get a chance to ask about the preliminary hearing. If I could just have a moment to speak with Mr. Kohitolu to see what he wants to do.
Well, since we're going to pass it one day.
Okay. He can, yeah.
And given the apparent conflict of the public defender's office, I think it would be appropriate
To leave that for
pass
tomorrow.
the case, to leave both items to be addressed tomorrow, and perhaps we can alert the alternate public defender's office to be present. All right.
Sounds good. Thank you, Your Honor.
Since they're not appointed on this case though, I don't, we still here. We would have to actually go through the process first, so technically the public defender's office is appointed on this case currently.
Certainly.
And typically, Your Honor, we are allowed to handle even co-defendant bail hearings. So I think our
Correct.
office can probably, but since the bail hearing is being held tomorrow anyway, I think he can decide on the issue of speedy prelim tomorrow, most likely.
All right, so let's pass this one day.
All right, so we'll see you tomorrow. Go ahead back to us.
Can I ask him to hang out for just a little so I can talk to him about the
And if we could recall Mr. Sheridan. And Ms. Gredvio, are we prepared to move forward with Mr. Sheridan?
Yes, Your Honor.
All right. My notes indicate the state presented, requested $20,000 bail with conditions. And defense, we left off, defense had not had an opportunity to provide a responsive argument.
Thank you, Your Honor. In this case, Mr. Sheridan indicates that, or rather the NPRA indicates 14 points. He indicates he has been in Reno for 2 years. We were able to contact his reference, his mother, Allison Duncan. Miss Duncan does live in New Jersey. She did confirm for us what Mr. Sheridan shared with me, that he had just been released from Renown. He had been at Renown for quite some time prior to his arrest. So he indicates that if he is released, he does have a place here in town to go to. Miss Duncan also indicated that Mr. Sheridan is free to reside with her. Of course, she does live in New Jersey, Your Honor, but she did indicate that he is welcome to stay with her. Mr. Sheridan indicates that he cannot afford monetary bail. For that reason, we are asking for an OR release. Also due to his inability to work, he indicates he had been at Renown for something like the last 90 days or so. I will also indicate, Your Honor, the probable cause sheet did not indicate any details regarding the failure to register. It just said that, he was trespassed. When they ran his information, there was a hit showing that there was a failure to register, but we have no details with respect to that. Although he does have prior failure to register convictions. Again, given that we were able to confirm through his mother that he had been recently hospitalized before his arrest, I believe she also she could not confirm his phone, but she had been in contact with him. He had called her from Renown. With that, Your Honor, again, based on his indigency, I would ask for an OR with conditions, including checking in.
The court finds at this time that the state has met its burden by clearing convincing evidence to establish that the defendant poses a risk of non-appearance. Scored a 15 on the risk assessment, which includes prior failures to appear within the past 24 months. The offense of trespassing is in itself non-violent. But nevertheless, the court is concerned that he is a risk of non-appearance. Bail will be set in the amount of $1,000 by surety or 10%. If he posts, he must comply with registration requirements upon release and have check-ins with DAS or the successor agency, as there is some evidence that supervised check-ins reduce recidivism and increase court appearance rates for high-risk arrestees. His next court date will be a 72-hour hearing on December 19th.
Thank you, Your Honor. So.
Thank you. Did we miss anyone?
I believe that's all I have, Your Honor.
All right, have a wonderful Sunday.
You
Thank
too.
you. You too.